for a residential development on land opposite Queensberry, Brae, Thornill. I'm Judy Craggs, and I'm a reporter with Planning and Environmental Appeals Division of the Scottish Government, which is commonly referred to as the DPEA, and I have been appointed to determine this appeal. This is a virtual hearing session and is being broadcast live, as I've just said. It will be stored as part of the DPEA website archives and will be capable of repeated viewing. And by participating today, you're consenting to being filmed. You're also consenting to the use and storage of the images and sound recordings, and of any images or information pertaining to you contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making these records available to the public. And any further details on our privacy policy can be found on the DPA website. So first of all, thanks my colleague Stephanie for arranging today's meeting. She is just hiding in the background and will step in with any technical issues, which hopefully there aren't today, but she's there anyway. So for the benefit of the live broadcast, can I ask the lead participant for each party to introduce yourselves and those participating on your behalf? So I'll start first with the appellant, please.
Morning, ma'am. Thank you. I'm Fraser Mitchell, a partner in the planning team at Shipper and Wedderburn, on behalf of the appellant. With me in the room, I have Alan Fitzpatrick, a partner at Montague Evans, who is the appellant's planning consultant. We also have participants in two other rooms. So we have Dion Corbett, who's the project architect from ECD Architects, together with Fiona Pennington, who's a development coordinator at the Whitney Group, and also Elspeth Lang in yet another group, who's the head of development at the Whitney Group. And just if it helps at this stage, ma'am, it's anticipated that Mr. Fitzpatrick will give evidence on most of the questions, or all of the questions, I should say, with the exception of question 4, which I will be giving evidence on, just because it has certain legal principles that sit behind it.
That's really helpful, so thank you for clarifying that. Now for Dumfries and Galloway Council.
Morning, ma'am. My name is Cameron Gregg. I'm a legal director at Morton Fraser McRoberts, and I'm appearing on behalf of the council today. We're joining in a room as well, likely just below Mr. Mitchell's. And in the room today, I've got my colleague Dan Strain, solicitor in the team, and I've got Louis Dawson, trainee solicitor at Dumfries and Galloway Council. We've also got representatives from the council joining remotely. So we have Graham Smith joining. He is a senior planner at the council, and we have Robert Duncan joining as well. He's a team leader at the council. At the moment, I'm anticipating answering most of the questions in the agenda myself, as they seem to me to have a legal angle to them, but certainly the planners are here to assist as and when required.
Yeah, thank you for clarifying that. And now for the Thornhill Community Council.
Hello, hi, good morning. My name is Elizabeth Shelby. I'm one of the community councillors, and with me is Christopher Craig, one of the residents of Thornhill, who's been long involved in the case round about the non-material variation. We don't anticipate anybody else joining us.
Okay, no, that's great. And will you'll both be commenting as we go through the agenda today?
Yes, we will both be commenting.
Okay, that's great. Thank you. Okay, just a bit before we start. When you're not speaking, can you please put your microphone onto mute, and that should avoid any background noise or feedback. There's no need to use electronic hands during the meeting. I will keep looking out for parties on the screen, and I'll ensure that you all have a chance to participate and comment on each agenda item and discussion point. So I will come back round, and again, to make sure everyone does have a chance to kind of make any final comments they want on a particular question, so you'll get a chance to participate. Phones and other devices must not be audible during the session. I know you're some parties are in different rooms, and you may require to message one another, which is absolutely fine, just as long as it's not audible. But if you're on mute, that shouldn't be a problem. if any of the parties needs a short adjournment to discuss the matter within their wider group when you're not all in the same room, then please let me know, and we can accommodate that during the course of the hearing. Now, I think, as I said in the procedure notice, I'm not anticipating that this session will go on all day, but we do have the whole day if necessary. And depending how we got on this morning, there will probably be a small break during the course of the morning, just to give everyone a bit of respite from looking at your screens. And finally, just a wee housekeeping note. I am taking notes during the session, albeit it is recorded because it's quite useful just for thinking, to write things down. So if you can just speak slowly while I'm doing that, I may ask you to repeat if I've missed something, but that's just the reason why. There's nothing else to that, just so I can capture the key points. As I said in my introduction, the appeal relates to an application for the approval of matters specified in conditions in Planning Permission 23/052/42. And due to the terms of the conditions, discrepancies in plans, and the complex planning history, I felt I needed further information on specific matters to allow me to determine the appeal. The purpose of today's session is to allow me to explore those matters, and in particular the planning history of the site and the proposed access road to the development, planning status of the access road, and what's approved and how that's been approved, and the implications of that for the determination of the appeal. And specific questions for discussion are set out in the agenda, and that was circulated to all parties last week, so hopefully you've got that. As advised in the procedure notice arranging today's hearing, the merits of and the substantive objections to the proposed access road location, alignment, design, and any impacts are not for discussion today, or these are not matters within my remit. So I'll be quite narrow focus today, and I will draw the discussion back if I feel it's going too wide. Similarly, the merits of the application and any merits in the objections are not for discussion, as I consider I have sufficient information in regard to those matters. So the hearing today is a structured discussion between the parties, and it's chaired and guided by me, and it's based, as said, on the agenda. That doesn't mean there's no follow-up questions. There may well be follow-up questions as we go through the discussion. And if any other party feels they have a follow-up question, then they can ask that through me, and we can widen the discussion out, provided it stays within the remit and the scope as I set out just there. I'm not allowing or expecting opening remarks from any party, and I'm not allowing or expecting closing submissions from any parties. I've sent this morning, just I thought might be helpful, a documents list of hyperlinks. Just I thought that would allow people to access quite quickly any documents that are referred to during the course of the hearing. It does not preclude parties referring to any other document that's on our website that I have before me. But we just tried to kind of make that a bit quicker for parties. But if you do need to go to another document that's on the case file, then please do so. And in addition, I have accepted as late documents the two cases that both the appellant and the County Council drew to my attention on Friday. So they can both be referred to in evidence too. So before we move to the first question, are there any procedural matters that any party wishes to raise, or does any party have any questions about the process? So I'll start with the appellant. Is there any procedural matters or any questions or points of clarification you want me to deal with?
Just one procedural matter. When I circulated the additional case on Friday, there was actually one other case that should have been submitted to that I'd like to refer to. I appreciate it's just being mentioned now. I can give you the name of the case. There's one point I would like to take from it, and I'm very happy to circulate either now or after this hearing session the case to the parties in case there's any comments that wish to be made on it. But the case that I would like to refer to, if possible, is called Fulford Parish Council against the City of York Council. And I can give you the citation as well, if that would be helpful, which is 2019 EWCA Civ CIV 1359. That's the case.
Before I decide to allow that or not, Mr. Greg, do you have any comments on that case going into the evidence?
Thank you, ma'am. It's unfortunate that it's just being raised just now. I haven't had a chance to consider the terms of it, but perhaps it can be circulated, and Mr. Mitchell can take what he wants. And if I have anything to add, I could follow up in writing after the hearing, if that would be acceptable.
The Queen's Counsel, do you have any comments you want to make on the fact of this case coming in just now as part of the evidence?
Yes, I think it should have come in on Friday before the admission date, and we shouldn't be looking at it.
That's like, given it's case law, and I'm kind of bound by case law. I think I'd probably have to accept it. But I would like it to be circulated now, and to be fair to the parties. Do you know which question you're likely to want to refer to it in? Is it question 4?
Oh, yes, ma'am. It's question 4.
Well, what I might then do is allow the case, but I have a short 10-minute adjournment between questions 3 and questions 4 to allow the other parties to at least read through the case. And then I'll consider at the end of the hearing whether I need any follow-up evidence on the point, just because I don't know the point you're going to make from it, how much detail you're going to go into, but that at least give the parties time to familiarise themselves with the terms of the case before you actually turn to it. So if you could send that to the case officer, copying in the parties.
Absolutely, ma'am. Thank you very much. I will do. And I mean, if it helps, I can direct parties to a particular paragraph that I intend to refer to as well.
That would help me.
Thank you.
Okay. Mr. Gregg, do you have any procedural points you want to raise or any points of clarification?
Nothing from my end, thank you, ma'am.
Thank you. And for the Community Council, is there any points, procedure points you'd like to raise, or any points of clarification, or any questions you have at this point?
Any questions, Christopher? Do you have any questions or clarifications? No, we've got no questions. Thank you.
Okay, thank you. Okay, so if we can turn to the agenda for today.
plan swap then supersedes the original detailed permission. Some reference should be made to the non-material remediation plan.
That it refers to the 09 permission, doesn't it, as the detailed planning permission for the access. So it's close to referring back to that first planning permission. Is my understanding correct that the non-material variation was made to the 2018 plan permission, not the original one?
Yes.
Sorry, I was just going to jump in there as the people who put in that application. Yes, the hatched area shown on the approved location plan for the Section 42 application references the 09 application. The no material variation, once approved under the 18 PIP application, was then put back. So on the portal, the 09 application does also refer to that same no material variation route. That's attached to both the 09 and the 18 permissions.
Okay, but on the face of the plan, there's the access here doesn't show the non-material variation, does it?
No, that's correct. It's a hatched area that refers back to the plan. There's on the Section 42 location plan, that access route area is shown as the existing context. So it shows a core path and there's no road access shown at all. It refers back to the previous permission.
I might actually come on to the council and just got a couple of follow-up questions on that. So when this Section 42 was approved by the council, were the councillors aware of the non-material variation, or were they did they take the plans and the permission at face value?
I'll turn to Mr. Smith for that one. Sorry, Mr. Smith, I think you're on.
You're on mute, sorry.
Sorry about that. Are you referring to the 180429 PIP application?
No, the 2023 Section 42 application.
So that would be 0452,
Yep.
Section 42. And can you repeat the question, please?
I suppose it's a few parts. It's what does the council think was approved in terms of the access road at that point, and what were the councils aware of in the committee report and the application itself as to what the access was going to be?
Yeah, I think we would need to look back at that, but that was just purely an application that related to the volume of traffic coming through the access as specified by another condition. So there was quite a narrow focus, I think, on that planning application.
Were the councillors aware that there'd been a non-material variation to the access?
I would be surprised if they didn't. It was a very controversial issue, but I'm not so sure that that application itself was that controversial when it was approved by a committee.
Well, if it's helpful, I would be available just now to go and check the planning history of that document. The key difficulty is the consideration of the case predated Mr. Smith's time at the council. So if it's helpful to Member the agreement, I could go away and check into these questions just now and then rejoin the call at a later stage, if that would help answer these questions.
I don't really want to go to evidence that I don't have, because I've also got evidence before me.
Yeah.
If someone wanted to look through the committee report and come back and confirm, which I've got the committee report, which is document ME005008. If someone from the council side wants to look at that and clarify what the position was in relation to access from the council's perspective, that would be helpful, and I can come back to that.
I've got the committee report in front of me for 230452, section 42. So that committee report in paragraph 1.4 talks about the access, detailed planning permission in respect of the road access and landscaping provision from Canal Street through a strip of woodland to the northeast of the site has also been granted under this permission.
If it helps, ma'am, just to maybe bring matters to a head, the council's positions is that the 2023 consent approves access from Canal Street in accordance with condition 3 of that consent.
Now, I wonder if I may, just to highlight other sections of the 2023 report to committee. There's reference in paragraph 2A in connection with the community council's objection, where they refer to the non-material amendment, so the new access position, and also in paragraph 4.4, there is reference again to the new access. Sorry, my apologies, ma'am. It's 4.5.
It's referring to the non-material variation there. Is that because it refers to previous applications? Is that what you're taking from that wording? Was it for paragraph 4.5 you're referring to? Just ask, because at 2.2a it does specifically refer to a non-material variation. But at 4.5 I can't see any reference to it. So I just wanted to clarify why we'd gone to that. How you think it supports the reference or to the non-material variation.
I'm not sure if he's maybe just on mute. He seems to be.
Mr. Rich, are you commenting on this point? Because I think you are on mute if you are.
Sorry. What I've seen was 2.2a refers to the non-material variation expressly. 4.5 does refer to a new access. What we're saying there is, I accept there is no reference to non-material variation, and it's just a new access that's being referred to. So it's clear whether it's non-material variation or the access is previously approved.
Thank you. So council position is that the Commission approves the Canal Street access. I'll come to the Community Council now for you just explain what your understanding is of what access was approved by the 2023 Section 42 permission.
So in reference to, we certainly were under the impression that the non-material variation was being carried through. However, we now know that non-material variation has not been carried through. So this section 2.28 is actually from us in terms of we talk about the non-material variation. Now, at the planning committee, unless the planning committee members were actually physically aware of where this road was, they wouldn't have any idea what the change was away from Canal Street to the C314. So it was the reference to within the planning still sits as Canal Street, and the maps that were produced or the references to maps are still Canal Street. So there is no specific reference to the variation as it was put in 2020.
Just on that front, if taking that a bit further with the appellant, do any of the supporting documents show the varied access?
Just answer that question in terms of the documents in the planning permission and the approved plan. The answer is no, they don't show the non-material variation access route. But my understanding is, well, actually, what I may do is just ask Ms. Corbett if she has any comment on that in terms of what was submitted with the 2023 application.
Thank you. Yes, ma'am, if I can jump into that for the Section 42 application, it's correct that the only drawing that was submitted with that application is the location plan, and in terms of the access, the only reference to that is a text note which states that the access is as per the 09 application, which, as I mentioned before, if you look back to that, the no material variation access route is attached to that permission as well. But in terms of the 23 approval of matter specified application, all the drawings which have been submitted under that application show the non-material variation access route, albeit outside of the red line boundary for that application.
Having looked at the design and access statement that was submitted with the 2023 Section 42 application, it seems to show the access from Canal Street rather than the non-material variation access.
I think in the very early stages of the design and access statement, there are some initial sketches and drawings which show access from Canal Street. That was purely very early stages while our design team was getting our head around the planning history of this site. But as the design and access statement progresses from detailed development and into all of the submitted drawings, there's no reference to Canal Street in the drawings as submitted. Oh, sorry, I can't hear you.
or I'm now on mute. Are you referring to the drawings that you submitted for the matter specified in condition application?
Yes.
Okay, I'll go back to that section 42 in 2023. At that point, did the design access statement show the access to Canal Street or the access or the non-material variation access?
For the section 42 application.
Yes.
There wasn't a design and access statement for that application. It was prepared afterwards, albeit we had been working on the project in advance of that. It was my understanding when we submitted the section 42 application that the access road would be the non-material variation route. But just for clarity, the design and access statement was starting to get prepared as we were initially appointed onto the project at very early stages. So some of the very initial sketches may have had the wrong access route, but my understanding is this was clarified by the time we submit the section 42 application.
If I could just add, the design and access statement showed the design progression as well. So when we first got the site, had the Canal Street access, and then as Dion says, as our team picked it up, that evolved and it changed. So then there may be reference to Canal Street in that the design and access statement, but it also shows how designs have progressed from there.
Okay, so just going to the design and access statement. And for example, looking at page 21, I have a chance to actually get the document. I haven't got that page 21, so this is opportunities for vehicular access. And I get this is showing the evolution of your design as part of the for mass specified condition. I get that, but the only accesses that are shown there as opportunities are the one to Canal Street and the one that's would be possible if those through the hospital land.
Right, yes, so this is from the very early stages of the initial design. When like I say, when we were first appointed onto this project, this was our understanding of the situation at that time. And then, as Fiona mentioned as well, on further investigation of the planning history, it was our understanding that the non-material variation access road is what was actually approved. And that was the basis upon which we submitted the whole application. I think I'm repeating what Fiona said, but I think it's quite common to show the and our understanding changed, and as I mentioned, all the submitted plans were as per the non-material variation route.
Okay, so taking that evolution into account, by the time we get to page 49 of the design statement, design access statement, that's showing there the non-material variation access.
Yes.
Yes, so that shows it coming out onto the main road. And then the text for that says detailed plan permission for the access road obtained under another application. So that would suggest to me that that access road is not approved under the section 42 permission. It's approved under a different application. You should marry up with the council's view that the section 42 approved access to Canal Street, not the access is shown on there, on that drawing.
Just from my side of things, what we had shown in the section 42 was the red line boundary, as per the 23 application as well, and we were working both applications simultaneously. But in the section 42, our reference does go back to the no material variation. Sorry, I'm not sure I understand your question.
I certainly don't wish to interrupt. I wonder if some of the this is so we anticipated dealing with on the question form we can deal with now. If my understanding is correct, it's the question in fact point of dispute is essentially does the non-material variation apply to the 2023 section 42 application? Does any reference in the application plan to the 09 permission, which was granted in 2013, does that undermine it? And I think our position is that the 2018 planning permission was subject to non-material variation. That's the permitted development that the section 42 application in 2023 then reapproved. And so it's pulled through if you like, in effect, the 2023 permission. The reference to 09 permission detailed site is simply an RI's reference to the detailed the access as modified by the non-material variation. By reference to the non-material variation being granted in 2020, that had the effect of the access arrangement, and that's what's referred to. Repeat myself in question 4 and just set that in a little bit more detail, but I think in lay terms, I think our position in connection with the 2023.
So before we go into question 4, because I want to have that short adjournment to look at that court case, your position is then that what the section 42 proved was access as per the non-material variation because it was pulled through as part of that process of changing just condition 11 from 2018 to the 2023 section 42.
I'm sure.
And that's despite the fact that it's not shown on any of the drawings, which we can come on to, but that's your position, is that it was the non-material variation access that was approved in the 2023 permission.
Still same, yes.
Mr. Gregg, your position was very clear. It was Canal Street that was approved. Is there anything else you want to add at this point before we go on to question 4, which will look at, I suppose, legal principle, how this would work?
I can say for question 4, ma'am, I mean, we're really dealing with the precise nature of what's being consented here, and that's a question of interpretation of the planning consent. I'm very happy to give you my view on that, but I appreciate you might wish to hear that after the adjournment. But yes, you'll have to answer any questions that you might have in regard to 3 just now.
I think your position is clear on 3, and I think we'll get onto all these points as question 4. Community Council, your position was very clear too. Is there anything else you want to add at this point before we get on to question 4?
Yes, in terms of the access approved by 23, the section 42, the reason why the details of that non-material variation were not included in the plan was it then would have been recognised that the changes were in fact material because of the extent of the access road, and that would have required an entirely new planning permission, because it was a material variation because it did not comply with policies and guidance, particularly LDP2 under NE8. It did not comply with the Nature Conservation Act or the Scottish Planning Policy 2014. It also raised amenity issues for the neighbours, and the scale of change had a negative impact in surrounding areas of high ecological value. So it should not have been a non-material variation. That would have been recognised if the details had been put into the planning application at that point. The councillors who were sat in that planning committee could not have been aware of the changes to the road because the location plans were vague and in fact showed no specific details of the road at that point.
Yeah, if you want to go into the specifics of the process with the non-material variation, because that's not before me. I don't have the detail, and I'm not going into that. But your point is that from the drawing, which was a location plan, they would not have been aware of that change at that point.
No, they would have, the Canal Street was what they agreed to in the plans and in the acceptance letter.
Okay, Mr. Gregg, you've got a final comment to make.
I think you've covered, ma'am. I was just going to make a point that I'm not sure this is the appropriate forum to raise concerns about the procedure that was followed in respect of the non-material variation. We have to work with the consent that we have, and obviously your remit here is to consider the appeal before you. I hope that helps.
Yeah, no, absolutely. I'm not here to look at that procedure or that process, or second guess what should be done there. It's just trying to get what was approved and what I've now got before me in terms of my appeal. Before we move on to question 4, is there any last comments from anyone? And if not, I will adjourn until, let's say, 11:10 to allow everyone to look at that new case that's come in, and we'll go on to question 4 when we get back. So that would be 11:10. What to do is, if you stay on the call, but just switch your camera off and mute, and then switch yourselves back on when you come back on the call at 10 past. Thank you.
Thank you.
Okay, welcome back, everyone. Can put the cameras on. Give everyone had time to have a quick look at that case. And we'll move on to question 4. So I will start with the appellant on this one, Mr. Mitchell.
Yes, Mr. Mann. The brief answer to this, as I alluded to under question 3, is that a non-material variation modified the 2018 permission, and therefore the modified development is the one that, so it's the only one that could be approved by the 2023 permission. In fact, the non-material variation applies to the 2018 permission, therefore it's been pulled through to the 2023 permission. And in our submission, it cannot be disregarded or placed to one side, since it is integral to understanding the nature of the development that's been approved. In terms of explaining how we arrive at that point, I would intend to briefly mention the planning history of the site, the statutory provisions around non-material variations, and then the relevant case law that's been mentioned in the Lambeth case and the Fulford case. So if we turn first to the planning history, and I suspect this is going to be a well-trodden path, but just in terms of clarity of explanation, I'm just going to run through it again. So 2013 permission, which is reference 09 P30355, was the first to grant approval for the development. It granted planning permission in principle for the residential component of the development and detailed planning permission for the access arrangements in the northeastern part of the site. The 2018 permission was granted under Section 42 of the 1997 Act, and it sought planning permission for the same development as the 2013 permission. It's subject to amendment to the timescales pursuant to applications for the approval of matters which were contained in Condition 1. Therefore, again, this permission granted approval in principle for the residential components of the development, the detailed planning permission for the access arrangements in the northeastern part of the site. In January 2020, the non-material variation was granted in connection with the 2018 permission. It modified the development approved on the 2018 permission to the extent it changed the access arrangements in that northeastern part of the site. This meant rather than access being taken from Canal Street to the north of the site, approval was granted for access to be taken from Townhead Street to the east of the site. The important point from this is that therefore, once the non-material variation was granted, the detailed component of the development and of the planning permission was altered. In September 2023, a further planning permission was granted under Section 42 for the same development as approved by the 2018 permission, but subject to the removal of Condition 11. That condition restricted the number of units that could be occupied before a second access was provided. And the council agreed to the removal of that condition primarily because it had been based on previous technical guidance that has since been updated. So for the question in dispute, again that we touched on under question 3, is when the 2023 permission was granted, development approved. Our submission approved the same development as the 2018 permission, but as modified by the non-material variation. So just to touch on the statutory provisions, there are 2 which are relevant to the question. The first is Section 64 of the 1997 Act, which comes to planning the power to grant a non-material variation. It provides, such as the provision itself, the planning authority may, at the request of the grantee or person acting with his consent, vary in the planning permission granted by them if it appears to them variation sought is not material. First, the wording of this permission is clear that the planning permission, as a result of the non-material variation, is varied. That's unlike a successful application under Section 42 of the 1997 Act. What I mean by that is the grant of non-material variation will not result in a separate planning permission being granted. It does not give the applicant the option to implement either the non-material variation or the unamended scheme that had first been approved. Only the proposal as modified by the non-material variation is approved. If the applicant wishes to implement the original scheme, they would have to seek a further non-material variation to modify the planning permission again. So, following the terms of Section 64, the non-material variation will vary the planning permission to which it relates, meaning the original unamended proposal no longer has the benefit of the planning permission. The second statutory provision is just Section 42(2) of the 1997 Act. This provides the planning authority shall consider only the question of the conditions subject to which planning permission should be granted. That's in the circumstances where they receive an application under Section 42. Therefore, Section 42 cannot alter the development that has been previously approved. It can only amend or delete the conditions that have been imposed on previous planning permission. The planning authority does not at that stage have the power to change the planning permission in any other way. And in our submission, this means when the council granted the 2023 permission, which was granted under Section 42, we're granting permission for the development that had been approved by the 2018 permission as modified by the non-material variation. Turning to the case law, and as I mentioned, it's the two cases, Lambeth and Fulford. The first is the Lambeth case that was circulated on Friday. The main point raised in this case is that a planning permission granted under Section 42, or in that case, it's the English equivalent, this quote from paragraph 11, can only take effect as an independent permission to carry out the same development as previously permitted, subject to the newer amended conditions. The question then arises, what is the development as previously permitted? In terms of case law, the second case helps with this. Rather than being told to you, that makes sense in the Fulford case. This is a Court of Appeal case from England. The central issue in that case was whether a non-material amendment, which is the English equivalent broadly of a non-material variation, can be granted in connection with the equivalent of approval of matters specified in conditions, so it's a different set of facts. However, the court did have to consider what constituted a planning permission, and the court found that it was not just the outline permission, but a package of planning approvals, beginning with the outline permission. I mentioned in paragraph 40 that we're seeking to rely on and look at. And in that paragraph, the court said, if a developer were to ask what development is permitted by the outline permission, the only possible answer is that the permitted development is to be found in the package consisting of the outline permission, any approval of matters, and any subsequent non-material variations. Therefore, in our submission, when the council approved the 2023 permission, they were approving the previously permitted development subject to different conditions. The previously permitted development, in our view, should be considered to be the existing planning permission, together with any non-material variations. This is the 2018 permission and the non-material variation granted in 2020. Therefore, in our submission again, 2023 permission granted a new planning permission by the 2018 permission. It was qualified by the 2020 non-material variation. So it's a fairly longhand way of explaining where we get to in terms of the relevance of the non-material variation and to approves, and which is why we say that it has to be read into the permission and read alongside conditions 3 and condition 6, 2023 permission. That enables the non-material variation. I would suppose supersede, but actually just form part of the permission. That's really true.
Okay, thank you, everyone. I've got some thoughts, but I'm going to let the council and the community council come in before I kind of go into this a bit more. So, Mr. Greg, do you want to give your view on this one?
Of course, thank you, ma'am. As you know, the council's position is that the 2023 consent approves access from Canal Street in accordance with condition 3 and condition 6 of that consent. So we're at odds with Mr. Mitchell in that regard. I think the precise nature of what's being consented here is a question of interpretation of the planning consent. We have to work with the consents that we have before us. The principles of interpretation are well understood, and they're helpfully set out in the Supreme Court judgment, which the appellant circulated on Friday, the Lambeth case. Lord Carnwath gave the judgment in that case, and he sets out in his decision that the starting point, this is a paragraph 19, he sets out that the starting point and usually the end point is to find the natural and ordinary meaning of the words used, viewed in their particular context and in light of common sense. We have to approach the matter objectively, and we have to consider what a reasonable reader would take from the consent. And in my view, that's quite clear in this case. 2023 consent grants planning permission under section 42 of the 1997 Act. And the proposal which has been granted permission is described as a residential development, including formation of access, road and landscaping, open brackets, deletion of condition 11 of planning permission in principle 18/0429/PMP to allow more than 50 dwellings from a single point of access, close brackets. Full list of conditions is attached to the consent, which quite appropriately mirror the conditions which attach to the earlier consent, save for the deletion of the previous condition 11 referred to in the description of the proposal. And as you're, of course, aware, of particular note, condition 3 and 6 provide that, unless otherwise agreed in writing with the planning authority, layout and landscaping of the access to the site shall incorporate access from Canal Street as shown on the specified plans. So in my submission, the natural and ordinary meaning of the consent is clear. And for my part, that's the end of the interpretative exercise. We have to work with consents we have, and in circumstances where the terms are clear, that's sufficient. However, it might be helpful to, as a bit of a sense check, to consider the context in which the 2023 consent was granted. It was, of course, granted following an application under section 42. Mr. Mitchell's already read out the terms, but if you bear with me in reading them out again, section 42 provides that the planning authority shall consider only the question of the conditions subject to which planning permission should be granted. And if they decide that planning permission should be granted subject to conditions differing from those subject to which the previous permission was granted, or that it should be granted unconditionally, they shall grant planning permission accordingly. So section 42 is directing the planning authority to consider only the question of conditions and to determine whether or not a fresh consent should be granted subject to conditions differing from those which attach to the earlier consent. In this case, the section 42 application only sought the deletion of condition 11 to allow more than 50 dwellings from a single point of access. And the planning authority, in determining the application, duly deleted that condition, and they copied the remaining conditions across to the new consent. It would have been open to the appellant to seek the variation of condition 3 and 6 as part of the Section 42 application, which would have had the effect of potentially incorporating the alternative access introduced by the non-material variation, but the appellant did not do so. I do, of course, accept that there was a non-material variation to the previous consent, which approved alternative access plans, but in my mind, that variation only related to that particular consent, which has now lapsed, and it didn't, of course, vary any of the conditions which attached to that consent. And also highlight in paragraph 16, paragraph 18 of the Lambeth judgment, where Lord Carnwath just read from, he's quoting from an earlier judgment of his, and he says that any such document, of course, must be interpreted in its particular legal and factual context. One aspect of that context is that planning permission is a public document, which may be relied on by parties unrelated to those originally involved. It must also be borne in mind that planning conditions may be used to support criminal proceedings. Those are good reasons for a relatively cautious approach. For example, in the well-established rules limiting the categories of documents which may be used in interpreting a planning permission, but such considerations arise from the legal framework within which planning permission is granted. So Lord Carnwath there advocating a cautious approach to interpretation. And in my submission, cautious approach should be taken here. I don't see a justification for embarking on rather convoluted interpretation to somehow bring across the non-material variation in circumstances where any attempt to do so would be in direct conflict with the clear meaning of the conditions which we do have attached to this consent. I think the natural order and meaning of the consent is clear, and condition 3 and condition 6 should be applied for their terms. Happy to take any questions, ma'am.
So I'll let the Community Council come in before I ask further questions.
Okay, thank you for that. I completely agree with Cameron Gregg about the what we have in writing is section 3 and section 6. Specifically says Canal Street, the landscaping and the road frontage. What I would like to say is that quite clear in the committee report for the 42 application is it should be noted that a decision and deletion of condition 11 would allow the additional time to implement the development, and if the application is granted subject to conditions, it will result in a new planning permission. So this is an entirely new planning permission, and the non-material variation was not carried through onto this new planning permission in any form whatsoever.
Thank you. Okay, thank you. That's helpful. I'll give the appellant a chance to comment.
Thank you. I suspect overall, in terms of the dispute between the appellant, the council, and the community council, it's a very narrow point, which is just does the non-material variation, does it prove what happens to it really? Just in that context, I think that's there's not actually a great deal of disagreement on a lot of the surrounding points. If I may just comment on a few things that were said. So Mr. Gregg mentioned that in section 42, 2023, only sought deletion of condition 11. It was open to the the appellant at that stage to ask for conditions 3 and condition 6 to be amended. Two responses to that. Number one is that in 2020, when the non-material variation was submitted, there was no suggestion at that stage that it had to be dealt with by way of section 42. And so our submission would be no need to do so at this stage. It may have helped clarify the position, but there's certainly no need to do so. The second thing is the terms of condition 3 and condition 6. You want to go ahead without adjusting those conditions or without seeking any amendment to them. Taking condition 3 as the example, deals with the layout and sets out the various requirements. And it has tailpiece wording before you get to the Roman numerals 1, 2, and 3, where it says the said layout shall incorporate the following features unless otherwise agreed in writing with the planning authority. And then Roman numeral I refers to the access from Canal Street. Now, that doesn't mean it must go to Canal Street. It means that that's the position at the point at which the planning commission was approved in 2018, but it does allow flexibility for the planning authority, the appellant in this case, to agree an alternative route. And the same position is the case under condition 6 when it deals with landscaping. Again, it has tailpiece wording before the Roman numeral requirements say that the landscaping scheme shall incorporate the following features of information unless otherwise agreed in writing to the planning authority. Now, the non-material variation in our submission in 2018 was an agreement, constraints the agreement writing with the planning authority. And it certainly was, it did have the effect of modifying the planning commission accordingly. So that's the first point. The second point was non-material variation related only to the 2018 consent. Our submission, as we've previously said, so also relies, so applies, I should say, to the 2023 permission as well. And this doesn't form part of the appeal. There's a legal question about what status the non-material variation has. And whilst we are not arguing this, we're arguing that the non-material variation forms a component part of the 2023 permissions, the internal part of it. One answer is that the non-material variation, which relating to exactly the same detailed access arrangements in the council and the community council are saying are in place, can be construed as an agreement relating with the council in relation to conditions 3 and condition 6 showing different arrangements. But that's been, we don't think that's where we need to go to, but there's a question mark over what the non-material variation would be, and it is relating agreed by the council to the appellant. Condition 18 in connection with interpretation of a planning permission. And again, I don't disagree with anything that Mr. Craig said. I certainly don't disagree with anything that the Supreme Court had said. Mr. Craig described it as being a convoluted approach to interpretation, and I don't think that's quite right. If you look at and also Mr. Craig said the context must be looked at. I think if you do look at the context of the 2018 permission, if you remember the public looking to see what has been approved, you may go to the planning board and see the decision notices there, and so is the non-material variation of the plans. And if you're also to see what was approved in 2023, see this is the 2018 permission, well, bearing in mind relevant regulations do not require much by way of information accompanying the section 42 permission. So you if you remember, that you may go back and look at the 2018 permission, and you would see development was approved in the decision notice. You can also see what development was approved on material creation. Just add the planning permission must be interpreted by a reasonable reader, but must also be considered to be reasonably well informed to understand the planning system. So then you assume that the reasonable reader interpreting planning permission would be able to do that exercise. Finally, on behalf of the Community Council, to the 2023 permission is a new permission. Again, just to we don't disagree with that at all. We agree with that position. But the key question for us is, what was the planning permission? What was the permitted development that was being issued under Section 42? Again, this is a repeat of a point that was made earlier. We considered 2018 permission as modified by the non-material variation. That was the development that was being considered by the 2023 application.
Okay, can I just come back on a couple of points? The Lambeth decision, if I read it correctly, kind of suggests that a reader should be able to take a document at face value. So if I'm a member of the public and I look at the 2023 section 42, which is a new plan permission, taking that at face value, what in that document tells me that the access route is not to Canal Street?
I don't think there's anything document. There's no detail in terms of the layout of the development would be or the access arrangements for.
Taking that document at face value, including the conditions, they would suggest to a reasonable reader that the access is to Canal Street.
Yes. You may see that on the regions are similar to the point at which it's going to the default position, if you like, Canal Street, with flexibility for a change to those arrangements.
And that flexibility is that phrase, unless otherwise agreed in writing with the planning authority. Does the appellant agree that, or accept that conditions 3 and 6 could have been varied as part of the application?
Yes.
Just a question on section 42 of the 1997 Act, which is the provision for non-material variation. And a planning authority may, at the request of the grantee, vary any planning permission granted by them if it appears that it's not material. Now, that would suggest to me that it applies to a planning permission, and that section 42 is a separate planning permission, and therefore wouldn't pull through to the section 42 because it applies to that a planning permission, not a sequence of planning permissions, but a planning permission. So it's very specific.
I don't disagree with that in the sense that it's referring to an earlier planning permission, but the key issue for us, and this is the key part of our submission, is when you look at what that planning permission is, we see the planning permission as modified by the non-material variation. So, if we have made an application, or if the appellant had made an application under section 42, 2023. So we're left with 2018 permission sought to implement that. The question would be at that stage, what is the planning permission that can be implemented? Planning permission can be implemented is not the planning permission was granted in 2018. It's the planning permission as it was modified by the normative variation. So if you like, that forms, and I suppose this is where there are submissions since that's the package. So the planning permission cannot just be looked in isolation. It must be looked at in terms of any modifications or any variations that followed on from it.
Section 42 is just concerned with conditions.
Yes, it's granting a new planning permission. So when you're granting the new planning permission, that new planning permission would be the planning permission as it was modified. So essentially, the old planning permission doesn't exist anymore as it was granted in 2018. The development, so the approval is the 2018 plus the non-material variation.
It's a relevant consideration on section 42 if it only relates to conditions. That non-material variation is that non-material variation is non-material by its nature. So therefore, when it comes to section 42, does that matter? It's all about, section 42 is all about conditions.
Yeah.
It's not really the development, it's looking at without complying with conditions.
It's looking at the planning permission, and again, you have to look at what the planning permission is. That in our submission is the planning permission as it's modified. It's previous planning permission. It refers to conditions subject to which a previous planning permission was granted. Well, the planning permission was granted to those conditions, and it was then the council accepted that a non-material variation could be granted in connection with that planning permission. So it's the planning permission as modified, which is subject to those conditions. So it's like the reason for planning permission, plus non-material variation.
Can I ask a question?
Of course.
Yes. I just want to know, if the details were agreed to the non-material variation, why were they not specified in the planning application in the S42, in the section 42? Why was it left as Canal Street? Was it a deliberate omission? Or was it a major error? That's my question, I think, to Fiona Pennington and perhaps the architects team.
I think it's a fair question as to why it wasn't dealt with in the section 42 if your position now is that it was incorporated in that.
I think I'm really speaking over something. So, I was just going to mention first, I think that this may potentially more of an issue with section 42 arrangements. There's no requirement under the regulations to put in more detail. It was submitted in connection with the section 42 application. Scott was very called to speak about that. But the requirements are to put in a plan sufficient to identify the land. Now, that's sort of regulations that have been passed by Parliament. So it wasn't a case of circumventing those regulations. It's just a case of adhering to what's required in order to put a Section 42 application and for it to be valid. I understand as well if it's helpful when the Section 42 for the 2023 permission was initially submitted, there was a degree of confusion. I think there had been one stage a notion that rather confusion over which planning application to refer to, but it was then clarified that the 2018 permission should refer to when making the Section 42 application, which is both obviously an approach that could have been taken, and also the design approach.
So if there was confusion over which planning application you were putting in, and you already had the confusion of adding in a non-material variation, why did you not take the opportunity to clarify quite specifically what access route you were asking for? Why did you leave it as Canal Street?
Spendington's code to current year. My understanding is that the Section 42 application was submitted in 2023. The confusion brief that was a mechanical point, just to make sure that the correct previous planning permission was being referred to, and the assumption at that stage being that the planning permission was the 2018 permission plus the non-material variation. So the point had essentially been settled in terms of what access arrangements would apply to the 2023 permission.
Just on that doesn't sit well with paragraph 1.4 of the committee report, which states detailed planning permission in respect of road access and landscaping permission from Canal Street has also been granted under this planning permission, referring to the 2018. So I guess it comes back to that point. The person asked it, and I think you said, out on the face of it, there's nothing on basically this permission which would suggest to a reasonable reader that the access was not to Canal Street.
Man, that's the case. I just qualified by my previous wording that there's no detail, in fact, in terms of the site development layout or the access arrangements. Canal Street is the only access point mentioned in conditions 8 and 6. All are qualified by the tailpiece wording.
That tailpiece, that unless otherwise agreed in writing, again, as a reasonable reader, looking at the 2023 permission, would you not assume that that would come after the planning permission is granted?
Well, you may do in the circumstances, but it wouldn't have to necessarily be the case.
It'd be funny if it happened beforehand and wasn't captured in the planning permission.
Well, this is where it gets, I suppose, it's one of the discussion because obviously has been done beforehand, it's been proved through.
I mean, I think I've got enough information from the parties on that. Are there any last comments people want to make on that? I'll start with the council, then the community council, then the appellant. Mr. Gregg, any final comments you want to make? I know where the nub of the dispute is, but is there anything else you want to comment
on? I think you have our position, ma'am. Very happy to answer any questions, any further queries you might have, but if it helps, I don't see a non-material variation automatically carrying through to a fresh consent under Section 42. In my view, it would depend on what that fresh consent, it would turn on the terms of that fresh consent. particular terms of that consent, which will be subject to the principles of interpretation, which we've been discussing today and which are set out in Lambeth. And in my submission, the interpretation of the consent leads to only one natural, ordinary meaning, which is conditions 3 and 6 apply. And yes, it's open to parties to agree a different access in terms of the wording of condition 3 and 6, but that hasn't come to pass.
Community Council.
Thank you. I would like to disagree with the fact that this is a narrow point of disagreement. This is a major point of disagreement. There has been long-standing concern within Thornhill about the access through the woods. The non-material variation was not open to public scrutiny. It was passed through planning without any discussion with the Community Council, and we actually found out about it by default later on. So we were not informed at all about it, nor were any of the residents. So in terms of, I think the NMV is being pulled through at this point in order to avoid compliance with National Planning Framework 4, which would obviously, if you'd been quite clear about the extent of damage that was being caused to the ancient woodland with the new access route, would not have been passed by the Planning Committee. If the non-material variation should not apply at this point because damage to the woods is actually quite significant. It does affect the local amenities as well. Thank you.
Okay, so my remit is not to comment on the process of the non-material variation or the merits of it. It's whether it does or doesn't change the access route at this point in time. I hear what you're saying, but that's not for my remit. But it is the point of disagreement as to the status of that non-material variation and if it applies to the 2023 permission. Okay, so if there's any final comments you want to make?
Just one, following on from Mr. Gregg's point on the interpretation and taking a interpretation of looking at planning permission on its face. The only comment I would make in addition to that is that when a non-material variation is granted, it doesn't change the decision notice. So when you're interpreting a planning permission that has been subject to a non-material variation, we still need to look further than the decision notice as it was granted itself. That would have been the case in 2018, where fixing what development had been permitted, and that comes back to the Fulford point, which is the permitted development is the planning permissions together with any non-material amendments that have been permitted. So there is that additional step that the reasonable reader would have to take, even in 2020, once the non-material variation sense permitted development was. So the reason for mentioning is that's the same position we're in. We are in 2025 assessing what the 2023 permission is. Permission you have to previous permitted development was the previous permission was released. So that's the 2018 permission plus the non-material variation. So it's essentially an error point, but just clarifying that in terms of interpretation.
And to not labour the point, is it not different for the 2023 permission because it's a standalone new planning permission?
Yeah. I don't need to do that. Only to say that I think when you are considering what the planning permission is in 2023, what you are issuing is previously permitted developments, the previous planning permission, which is 2018, as modified by the non-material variation. And we argue the non-material variation has status and has changed the 2018 planning permission to the extent that the original scheme no longer had approval.
Sorry, if I could just add that that was the basis on which our application was made, on the understanding that that approval was valid. So that's why we hadn't addressed that in the further application, because the non-material variation had approved the access.
Okay, thank you for all the contributions to that question. If we go into question 5, it's probably the same process between question 5 and question 6, just one deals with the layout, one deals with landscaping, but both conditions also refer to a set of plans that show access to the site from Canal Street and have certain requirements that must comply with these plans. Now, I think just bearing what we've got to in our discussions so far, it'd be good to get party views on. There's two scenarios. One, if I accept the position that the non-material variations carry through. Another scenario that I take the view that it's not carried through and the Section 42 permission is as it is. So if you can kind of maybe answer them both. One's quite an easy position probably. If it's carried through, it's probably quite simple. But if we can just comment on both those in relation to questions 5 and 6. If we do question 5 first, it might just be question 6 as a repeat of what you said for question 5, which is fine. So I'll go to the appellant first.
So our view is that, as we've discussed, is that the non-material variation should have been carried through, as discussed previously. And as part of the Section 42 permission, it should make reference to Canal Street. It should have been to the non-material variation.
It does make reference to it. So, on taking it at face value, does the application comply with the condition?
I think the application, if it were to be granted in its current form, I think there would be a small variation needed in the detail component, because the entry point of the access road sits to the detail part of the site, sits slightly further to the north on this application, and located slightly further to the south. If it's the Canal Street.
If I take the view that the non-material variations carry through, so therefore I can hang my hat on the wording of unless otherwise agreed in writing with the planning authority, I would then naturally have to follow through from that and say that limb 1 of condition 3, for example, should be interpreted in accordance with that non-material variation, and therefore it would comply, even though it doesn't comply with those drawings. Is that a fair summary of what I should do in that situation?
Yes.
And if I take the view that it doesn't pull through and the Section 42 permission should be read on its face value, I just take the view that what has been submitted doesn't comply with the condition, or that part of the condition.
You can still take the view that it has complied with the condition, because its approval basis would be an alteration to the agreement meeting. What then would require, I think, is a further amendment required to the detailed component to ensure that the access road actually sit within the two would connect, basically, which they be slightly off centre under the proposal. Our submission is if the goes through accordance with condition 3, if you grant, then that would bring you in accordance with condition 3 as well, to say that the NMV doesn't practical matter, there need to be a slight variation to the detailed permission.
So are you suggesting that for me to reach the view just based on the 2003 permission, assuming that non-material variation doesn't pull through, I would have to approve the variation as part of this appeal?
Sorry, no, that would be a matter that just have to be dealt with by the appellant after the.
It sounds like the first bit of condition 3 is quite specific. Access to the site from Canal Street shall be provided in accordance with the details in various drawings. The application doesn't do that. So if I don't consider the non-material variations being carried through, is the natural conclusion that it doesn't comply with that condition, your application doesn't comply with the condition?
Well, it may not comply with part 1. You're entitled. It may not comply with 1 in a position where this is otherwise agreed. You come to the stage to seek approval for any changes that would be needed.
Would that agreement not need to come first?
Well, it's not necessarily, because what you're doing here is looking at the planning permission and principle part of the development. And that's what the MSC relates to. This condition relates to the detailed part of the permission. So I don't think it would be a case that would be necessarily with.
If, for example, this permission hadn't said anything about the access route because it was an outline plan permission principle, so part 1 of condition 3 wasn't there, I can see why it's kind of out with my remit. Different planning permission, you'd have to either sort it out or rely on non-material variation or however you dealt with that. But given that part 1 of the condition, if the application doesn't comply with that, what should I do in my decision? Does it matter it doesn't comply with that?
My overall view is it doesn't matter. You don't comply with that. If an alternative view is taken, you could reserve further the approval of the access from the application site, so more restricted the MSC site, and going into the detailed planning permission part of the site.
I'll come to the council, Mr. Craig.
Thank you, ma'am. Sorry, ma'am, I think you're on mute, but
It looks like you're on mute, but I can't hear you. But yeah, I can hear you. I think everyone else can.
We're using a room audio system, so I'll go on mute on my screen. So I think the council was of the view that the internal layout that's been provided could link into the access from Canal Street. I understand that's not what we're hearing from the appellant. Is that right?
Sounds like it was slightly off from what I took from what Mr. Mitchell said. It doesn't neatly join. There'd be a slight discrepancy between where it comes in and where the access road is shown on the plan.
In that case,
First of all, Mr. Mitchell, is that fair? I'm not trying to put words into anyone's mouth. Is that a fair summary?
That is a fair summary. It doesn't tie in exactly, slight. It just seems slightly off centre.
Okay, no, thanks.
okay, thank you for that. Smith, Mr. Duncan, do you have any thoughts in light of that?
Just looking at that, sorry, condition 5, sorry, 0.5, so we're looking at 0.1 of condition 3, rather. Apologies, Mr. X and myself there. It seems quite straightforward to me that you would look for compliance with those drawings that are mentioned. As I understand it, the applicant is saying that it's not possible to get something that will comply with those drawings, and therefore you can't satisfy the condition by doing that, which would indicate to me you could possibly deal with that by means of a further non-material variation. But that would be after the event, after that planning permission had been granted, and that would happen.
So if the council feels that they can't comply with that first part of the condition, what should I do with the appeal? Is it black and white that it doesn't comply with that provision, therefore I refuse the appeal? Or does it matter, it doesn't comply with that part of the condition exactly?
Well, I'm looking at that on the basis that you've got a decision relating to Section 42 application. That's not in dispute, and that condition has been pulled through from the earlier permission. And no one's looked for that condition to be changed as part of the Section 42 application. It's only relating to condition 11. Case officers decided that conditions 3 and 6 don't need to be changed from the previous planning permission. He's presented that in his report to all parties. He's presented that to the elected members, and the elected members have agreed with that decision. If in reality the appellant finds that adhering with those drawings doesn't meet with the required approval, for example, from the Roads Authority or whatever, or it doesn't arise in a practical solution, you would probably need to rely upon the phraseology within the condition unless otherwise agreed in writing with the council's planning authority. And I think just for completeness, you would probably deal with that as a non-material variation as well as a formal discharge to that planning condition. From your own perspective, ma'am, I think you just have to go on the basis of what's the information that's in front of you today, and clearly it's part of that planning permission. So I think the question was which access arrangement has planning permission, which does not. Was that correct?
I'm trying to establish what your views are of if the drawings obviously don't comply with those drawings, because that's not where the access is coming from in terms of the non-material variation. So I'm trying to establish if that is a non-compliance, how I deal with that. Could I take the view that, and this was suggested, I suppose we're moving on, kind of dipping into question 7.2 actually, but could I take the view that where it says unless otherwise agreed in writing with the planning authority, I am now stepping into the shoes of the planning authority because I am determining the application. Therefore, I could agree as part of my decision that it doesn't need to comply with that, and allow, I think as Mr. Mitchell said, and you suggested, that the access is subsequently determined by the council. So I actually don't, it's not within my remit to comment on the access route or otherwise, or whether it's got permission otherwise, but could I take the view that unless otherwise agreed in writing is my agreement to not have to comply with that part of the condition, and I reserve by condition or otherwise the approval of the access to the council. Is that something I could do in my remit, or do I have to take the view that if it doesn't strictly comply with that part of the condition, I must refuse the appeal?
I think, ma'am, it's quite difficult for the council to provide advice on this. As you know, the council's already determined that the internal layout is unacceptable for the reasons in the decision notice and the reasons that have been addressed in further submissions, none of which refer to the access.
Totally, I wasn't trying to cut across that. I was coming from my perspective. If all things being equal, I find all that acceptable. Just how would I deal with actually the wording of this condition? I'm not trying to put the council in a position where it changes position at all. So I didn't mean to do that.
No, I appreciate that, ma'am.
I think it's a question of materiality. So you have the condition, you have the precise wording. We're being told that wording cannot be met by the applicant. So inevitably, as the planning authority, you're looking at a different proposal, and then you're making a judgment call as to whether that's an acceptable change or whether it's a non-material variation. So those are two different things. Is the change acceptable in planning terms? So that's a call on the merits of the revised proposal and the revised condition approach, basically. And secondly, in terms of process, how do you deal with that? Do you deal with that as a non-material variation as well as a discharge of that condition, but something alternative to what's specified within it?
What I'm trying to get to is whether, in terms of the condition, because it says, unless otherwise agreed in writing with the planning authority, I can step into the shoes of the planning authority and agree my decision that it no longer has to comply with that part of the condition. Can I do that? I guess I'm just seeking views.
I think, ma'am, for my part, it's probably something that we'd like to go away and consider a little further if you are looking for guidance on that, to the extent to which you can step in to the shoes of the planning authority in the absence of such agreement. As I say, the council's preliminary view was that there was no issues with the lining up of the internal layout and the approved access onto Canal Street, but I appreciate the appellant will have a greater understanding of the detail of their own application. So I think it's something we'd probably want to go away and consider a little further, if that's okay, ma'am.
Okay, I can consider after this hearing whether I want to follow that up in writing, because that was a slightly different position on the lining up point. Okay, I'll come to the Community Council and then I'll come back to the appellant. Michelle, do you have anything you want to add?
Well, in terms of, obviously, the plans do not comply with the new access route, so it needs to be through Canal Street drawings. And I understand there were issues with the Canal Street. The slope was actually a 1 and 2 at one point in that road in terms of the pavement coming through. So the fact that there's been no full assessment of that access route. Things like transport assessment have all been through the connection onto the C134. So I actually think there's no choice but to just reject this appeal because the Canal Street is not being fully assessed.
Okay, so it was the access road onto the main road, not Canal Street, that's been assessed, is your position?
Yeah, that's been assessed in terms of what the slope has been like and what the roads department said about the joint junction. And I understand roads department were consulted at one point about the non-material variation because they had questions about the Canal Street access. So I don't think you can go ahead and say this has been an appropriately assessed planning permission.
Back to the appellant, just to any final comments.
Yes, just a couple. We'll actually pass to Ms. Corbett just to confirm. But my understanding is that the junction, the Town Head Street junction, as we would see, it's being approved junction was assessed as part of the MSC application. but I'll introduce those to confirm that. One thing I would draw to your attention, ma'am, is that this just relates to the position of the council. So in the report to committee for the EMSC application, which I think is document ME1-001, in paragraph 4.13, and that's under the heading of transportation. There is commentary in terms of commentary and analysis, I should say, in terms of the EMSC application. And in 4.13, the council here say that access to this development onto Town Head Street has already been approved through previous applications. Most recently, application 23-0452-S42, and no changes are proposed to that. So, just flagging in terms of making it clear what the council thought was the commission when they looked at this EMS, which may help when considering to deal with conditions 3 and 6.
I'll let the council come back on that point because that's a new point that should be raised.
Thank you, ma'am. Yes, I know what it says at 4.13 of the committee report. Those are the terms. It might just be a case of more accurate language could have been used, but I can't speak to what the draft had in mind. Was Tower Street was joined on to Head Street. As to the scope of the AMSC application, my understanding is that doesn't seek any detailed consent for the access. I don't know if that's what was being suggested there, but that falls out with the access arrangements, of course, fall out with the red line boundary of the appeal site under consideration today.
It was my understanding, the Mr. said it was assessed as part of the MSC application. Do you mean that, as Shelby's alluded to, that the transport assessment is assessed it as part of the MSC application, or do you mean the council assessed it as part of the MSC application? I think you're mute if you're speaking.
Apologies. I would our team's maintenance call to give you the detail on that.
Yes, so the transport assessment as part of the MSC application was based on the non-material variation route. And that was assessed, yeah, with that location.
So we're saying it doesn't form part of the application, because you're not seeking approval for that access as part of the MSC application, are you? So it's not my remit to prove or otherwise the actual access route. I'm looking at what's in the red line. So it doesn't have in my mind that it was assessed as part of this application, albeit your transport assessed it.
I was just going to say, I think that's right. It was the statement was just in case of council.
I think the council they accept the fact that there's no assessment. I think the council what position was there was no assessment of the Canal Street access. And I think we all agree.
Yes, that's what we're saying.
Yes, so the position is kind of accepted that the transport assessment assessed Town Head Street access, but there's no assessment of Canal Street access. So I think we're all kind of agreement on that. But I think my position is that this application, the MSC application, is not seeking approval of the details of an access road at all. It's everything within the red line, not the access road. So I just think is it a bit disingenuous to say that the council assessed that access road as part of the application when that's not part of the application, albeit it was part of your transport assessment. So it has been assessed technically. I'm not sure. I'm convinced that the council assessed it as part of the application.
It's fair enough.
Okay, question 6 is somewhere it relates to landscaping, and I'm not sure I'll gain anything from going through that. It's the same position we just discussed as to whether I can step into that and otherwise agreed in writing. So I'll think about whether I need to follow that up in writing and seek further written submissions on that point, clarify parties' views on that. Is there anything in particular anyone wants to say in relation to question 6, or is everyone happy that I move on to whether you could add a condition if I was minded to grant the appeal? Mr. Mitchell, are you happy to move on to question 7?
Happy to move on now.
Mr. Gregg?
So I have to move on, ma'am. Thank you.
Michelle, are you happy to? Okay, thank you. So I'll go to the council first on question 7, which was this condition that the council proposed, and just really to understand, does it meet the test in the circular, and how would it rectify any non-compliance with the conditions?
Thank you, ma'am. I don't think it would rectify any non-compliance. The council had understood that there wasn't non-compliance with discontent already. I do think, though, if you were minded to grant consent, council's views that a condition in similar terms to that proposed would be helpful in providing clarity around what's being consented here as part of the appeal. And that's really because there are plans submitted with the appeal which show the alternative access arrangement, albeit out with the appeal site boundary. But the concern is that those plans might introduce some confusion as to what access is consented. And the proposed condition, I'd suggest, is relatively standard wording that just seeks to define the permission and provide some additional clarity there.
And where it refers to previously approved details, is that access to alignment to Canal Street?
Yes, to be fair, ma'am, I think if you were minded to refer to specific plans there to tie it in with condition 3, that might be sensible, just to provide more precision to the condition. I would suggest that it meets the tests of being necessary, relevant to planning, relevant to development to be permitted, enforceable, reasonable. So it's happy to go in those in more detail, but that's my submission. I'm very happy for more precision to be added with the points that we have. Smith, do you have anything to add to that?
No, it's a fairly straightforward, almost standard condition you would add to a permission, to just for clarity more than anything else.
Okay, Mr. Mitchell.
Thanks, Will. Just a couple of comments from me. The first is supposed to say that if I'm not sure, I want to talk about Mr. Fitzpatrick look at the tests, but I'm not sure it's a condition that needs or can be imposed. And probably more needs to be imposed more than anything else, because if the council are correct in terms of the NFV, then I don't think it really adds anything to the permission. The second thing is it's regulating the access on a parcel of land which is not within the red line boundary. You got round the developer controls that land. but you've already got a planning permission which does in detail control what's been approved on that site. So certainly looks as though it would not be a necessary condition to impose. So Mr. Patrick come in on the substantive points.
So yeah, just when you look at the various tests under the regulations, so just to look at them, so planning conditions should only be imposed where they are necessary, relevant to planning, relevant to the development, to be permitted, enforceable, precise, reasonable, in all other respects. So I'm not quite convinced that the condition would meet all of those tests. Whether successful in doing
What test wouldn't it meet?
that. Whether it be necessary. And also whether it be relevant. It could be considered as precise. Also whether it would be enforceable.
I wonder if I might also say that if you were minded to impose a condition on a basis, and this may be one that need be dealt with in any follow-up submissions, I'm not sure. I can see what the council are trying to achieve by imposing this condition, but they may end up cutting across what it is they're trying to do. I think this is intended to be to provide clarity that the NMV hasn't pulled and it's no longer the relevant approval for the access. If that is the case, and it's just a precision point, I think the wording of this may still enable the NMV to be relied upon. In terms of referring to be implemented in accordance with the previously approved details.
Yeah, which is the point I made earlier, that I think Mr. Gregg, I think the purpose of this is to just clarify what has been approved in terms of the access, because there are discrepancies between the various plans and discrepancies between the plans and conditions. And so I questioned that from the council's perspective, the reference to previously approved details would be amended, if I was minded to grant a thought all appropriate, to refer to the plans in condition 3. So it was very clear that what had been previously approved was the Canal Street access. And I think that was what Mr. Gregg was agreeing.
Yes, ma'am. I'd be very happy for that. I think that'd be helpful, actually, to have that additional precision there. For my part, I think it is there for clarity, but I think that clarity is necessary given that a number of the plans do show the alternative access, and you've got to consider people approaching this consent in years from now, maybe successor parties trying to make sense of it, much as in the same way as we're doing with the interpretation of the underlying consent. And I think a condition would be necessary to provide that much needed clarity. I think it'd be relevant. Vehicle access is, of course, relevant to planning. You've got a landlocked site being consented here, dependent on access being provided. Council's content, they're confident the condition could be enforced, and we've discussed decision already. So that's the council's take. I don't know, Mr. Smith, if you have anything further to add on those points raised by the council.
That's helpful. I'll let Ms. Shelby come in and comment on this, and I'll go back to the appellant.
I've got no comments to make on this point. Thank you.
Mr. Mitchell, Mr. Fitzpatrick, do you have any final comments on this?
The only one is to say that I think whichever way it's cut, we still maintain that it's not necessary.
Let's move on to question 8. And this was Mr. Formstone's written submission, which is hyperlinked to that in the agenda. And it was just to give the parties a chance to comment on that as far as there's anything left that's not been said so far in relation to the other agenda items. So I'll start I'll do the appellant, the council, Community Council, then go back to the appellant. There may be nothing to add, and that's absolutely fine if there's nothing to add. It's just make sure that any final comments are picked up.
We don't have anything to add to either Mr. Formstone or Mr. Craig's emails. I think the points that raised in both have been dealt with in some detail, and we would definitely fall into the realm of repeating. So we don't have anything further to say.
Okay, that's absolutely fine. Mr. Gregg?
Council's in the same position, ma'am. As I mentioned earlier, I don't think this is the appropriate forum to raise or determine any concerns regarding procedures that were involved in the handling of these previous consents. We have the consents that are on the books just now, and they're the ones that we need to work with and interpret and apply, as far as they provide context to your determination of the appeal. So nothing further to add unless you have particular questions for the council. Mr. Smith, Mr. Duncan, do you have anything you'd like to say in response to these points?
I mean, the only thing I was going to say that's not for the appellant, it's not for yourself, ma'am, is that the council obviously has an established process to deal with complaints and comments from dissatisfied members of the public, but that would be something that would be related to the council's handling of the case rather than your consideration of this case as an appeal, ma'am.
Yeah, I agree. That's a matter for the council. Shelby, do you have anything you want to add in relation to both these two documents? Or Mr. Craig is still there?
Mr. Craig does. Mr. Craig, someone's heard.
The decision in 230452 S42 was made after the Planning Applications Committee considered. But the Planning Applications Committee cannot surely have approved something of which it was not aware, i.e. the variation. Can we go into the validity of the variation?
No, that's not within my remit. The council has granted the non-material variation. It's not before me. It's not for me to open that up or consider whether it's the right thing to do. That's not matter for me. That is the council. I'm just deciding whether that applies and has been pulled through and to the 2023 permission, but it's not for me to be looking at process or the validity of that, or I only got comments about consultation and compliance with the development plan, but that's not for me. It's not before me as a consideration.
I would submit that it is.
I can only consider the application that was put in, and that was the application for the approval of matters and condition. And what I'm trying to establish in deciding whether to allow that appeal is how the access route, the implications of the access route and what's been approved, how that impacts on this application that I'm looking at.
In the position up to the political.
Sorry, Victoria, you broke up there. I didn't catch any of that.
Oh, sorry. Okay. So I'm not looking at whether it was right to grant the non-material variation or whether the process was followed. I'm trying to decide that whether the application that I've got complies with the conditions that they're trying to satisfy. That's what I'm doing. So I'm trying to establish, based on the word and the condition, whether it does that. I'm not looking at the validity of the non-material variation, whether it complies with the development plan, whether it was the right thing to do, whether it was adequate consultation. All I know are issues that you've raised, but that's a matter for the council. It's not a matter for me.
Okay.
But I would submit that for you is a consideration of these points with respect to section 42, in that they are changing the description of the application. And for reasons set out in the David Formstone's objections to the variations, they are substantial changes. Furthermore, the section or the Condtions decision, I believe, brings into play the environmental considerations, which, so far as I can see, were not brought to the committee. That's the LDP2, the fact that this was an ancient woodland, and also the NPF4. And those surely should have been brought to the committee, and they have not been, so far as I read it.
Again, I'm not looking at the section 42 application, how that was granted or what was considered by the council at that time. That's a given. So that section 42 has been granted by the council. It's a live plan permission, and what I'm considering is whether the application put together by the developer for the detail showing the layout and the landscaping, different types of houses, materials, finishes, whether what they've submitted complies with the conditions that are set out in the section 42. So that's, I've got quite a narrow remit. I'm not looking to open up the section 42, decide whether it was right to grant the section 42. I'm not looking at whether it was right to grant the non-material variation. It's very much, is what has been submitted to me sufficient to comply with the conditions in the section 42 planning permission? Mr. Duncan, I'll let you come in since you put your hand up.
So thanks, ma'am. It's just to reiterate to all parties, there is a comments and complaints process for people that are dissatisfied with the service they've received for the council. And I'm quite willing to share details of how you go about engaging with that process with any party. If they're willing to provide their contact details to me, it's simply robert.duncan@dungal.gov.uk. I'll quite happily help out that way and provide details of that if that offers you any assistance, ma'am.
Mr. Craig, do you want to come back and make any further comments?
I would comment slightly to one side. The discussion this morning has emphasised greatly the ambiguity of the grant here, in particular between Shelby and the others who want to interpret the decision as including the variation. And my understanding is that a planning application should be clear. Clear, quite obviously, is not. I'm allowed to introduce the Councillor Giusti and his putting of a motion, or starting to put to the committee a motion to reject this application on the basis of the NPF form. that he was interrupted by the legal officer, saying that that was not permitted because the council previously granted the access, which actually was not correct. They had not granted that.
That is a matter for you to take up with the council. If you feel that was not correct conduct or proper conduct of the council, then you should raise a complaint with the council on that matter. Again, it's not for me to look at the conduct of the council or the councillors as part of the granting of the Section 42, but that would be a matter, as Mr Duncan suggested, that you could take up with council in the form of a complaint.
I did, but in my email to Mr Rogers, but he refused to comment on that.
I think Mr Duncan's invited you to make a complaint, which you can do, and councils tend, I don't know Dumfries and Galloway's complaint process, but councils tend to have a complaint process which you'd submit your complaint not to the person who didn't respond to you, but through a formal, proper process. And if you're dissatisfied with that process, you can ultimately go to the Ombudsman to get a decision on that. But that would be a different channel to my determination of the appeal, but it is a channel open to you, which doesn't impact on my role at all.
My recourse is to go back to the council, and if they refuse to hear, what can I do then?
You'd have to exhaust the council's complaint process, and Mr Duncan said that he could explain what that is and put you in contact with the right people. My understanding is generally for councils, if you go through that process and you're dissatisfied with the outcome, you can go to the Ombudsman, who would look at your case, which is kind of like an appeal, like I do, but it's of how the council handled your complaint. And I'll let Mr Duncan come in because he probably knows more about this than I do, to be fair.
Thanks, ma'am. Just to reiterate what you've said, there is a stage 1 complaints process, there's a stage 2 complaints process, which is also with the council. Beyond that stage, you do have the right to go to the Scottish Public Services Ombudsman. Now, the other point you made, your email to Steve Rogers, Steve Rogers no longer works for Dumfries and Galloway Council, so you should probably go through the formal process, and I'm happy to share details of that with you if you can email me.
Okay, thank you.
Does that help? And you should have Mr Duncan's email address from exchange of documents and things like that.
It's okay, but I'll share the details. I know the complaints procedure from Dumfries and Galloway Council, and I will share that with Christopher if he wants to go ahead with it.
Okay, so that would be in parallel to my determination of appeal, and the two of them don't preclude each other, so that's an entirely separate process.
Yeah, thank you.
Okay, are there any final comments from anyone? I'm just looking around my screens. No one's kind of waving or showing they've got anything else to add. So we've covered all the points on the agenda. It's clear to me what the issues are. I will consider whether to follow up on a couple of aspects in writing to get some further written submissions, just given some of the evidence that came out today. And I'll do that. That would come out from the case officer, and we would probably do that by the end of this week, start of next week. So probably got a chance to comment. And other than that, I'd like to thank you all for your contributions. It has been a helpful session from my perspective, just to explore this a bit further. I appreciate you all taking the time to take part today. The target date for the decision is, I think, the 23rd of September. So I'm confident we can do the written further procedure within that timescale. The case officer, Rebecca Brown, would be the one that would issue the decision, and she'll issue any correspondence for any further evidence that I need. And in the meantime, if you do have any queries, please contact Rebecca and she'll be able to help you. But we will be in touch, as I say, by the end of this week, beginning of next, to clarify what the next step is based on what we've heard today. But thank you again for your contributions and your attendance, and you're free to leave the call.
Thank you.
Very much.
Bye.
Thank you. Bye, everyone.